Hello, everyone. Wow, it's the second time in the same day. That hasn't happened for a while. So I wanted to go through the order on Stephanie Jones's motion to dismiss Wayfarer's counterclaim. Before I do, I'm going to take a victory lap because I did my video a few hours ago now, and that was on the opposition letter that Lively wrote to Judge Lyman, asking him not to grant Wayfarer's request for an extension of the pre-trial motion deadlines. And the letter hit the docket after the judge had already granted it, so she was shit out of luck, which was just delightful. But when I got to this line, I said, really, really clearly, that I thought that it's kind of an irrelevant statement. So the only reason that is there is for PR. Miss Lively is and always has been prepared to take her case to trial and objects to any further attempts by defendants to delay her ability to do so. And I sat and I was like, I got really angry actually at one point. I was like, they're not attempting to delay anything. They're asking for an extension, which is not unreasonable. She's asked for dozens of them herself. So yeah, I was like, this is just for headline. This is purely so the mainstream media then grabs it as a headline, says, Justin Baldoni's trying to delay, blah, 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 and runs with it. And sure enough, this popped up not long ago. That's exactly what happened. So I'm frustrated that we can now predict with military precision what is going to happen and what Lively's motives are, and what is the underlying sort of foundations behind each and every one of her actions. But here we are, a year on. We've got that ability now. We are now experts in Blake Lively and her lawsuit. And it's frustrating that the mainstream media is still kind of stupidly taking the carrot, really, and just going, oh, okay, then Blake Lively says that Justin Baldwin's trying to delay everything. Headline. It's... I don't know whether sometimes there's an agenda or they really are that stupid. But anyway, I'm not going to go on another rant because I got a lot off my chest earlier. But this is there's mixed emotions with this court order now. So yeah, nothing's happened in the Jones docket for quite a while, and it's nice to see some movement. So Stephanie Jones obviously filed her complaint against both Abel and Wayfarer. Abel and Wayfarer then subsequently and individually filed counter complaints. Stephanie Jones filed a motion to dismiss for each of them, and we've already had rulings on the Jen Abel's motion, on her motion to dismiss Jen Abel's counterclaims, which were, I thought were quite reasonable actually by Judge Lyman. I was quite pleased to see a lot of them remain. A lot of really fair and reasonable causes of action too. So I'm looking forward to seeing how that pans out for Jen Abel. But we hadn't had a ruling on the counterclaim motion to dismiss for Wayfarer. So I'm just going to read this little bit of procedural history. I'm not going to read the background. We know the background now, to death and back. We know this case inside out. So I won't add, 20 minutes, half an hour to this video by going over stuff, which is basically just repeating myself. I also won't go over the legal standard. We now know what a legal standard is for a 12B6 motion, a motion to dismiss. So, I don't feel like I need to go over all of that again. But the procedural history. So The Jones parties instituted this action by complaint filed in New York State Supreme Court on December 24, 2024. The complaint alleges that Abel breached her employment contract with Jones Works and that Nathan, Baldoni, and Wayfarer tortuously interfered with Abel's employment contract with Jones Works. It also alleges that Wayfarer and Baldoni breached the agreement with Jones Works and that Abel and that Nathan tortuously interfered with the agreement. The Jones parties also assert claims for faithless servant, breach of fiduciary duty, and defamation against Abel, and for defamation against John Doe's 1 to 10. On January 27, 2025, Wayfarer and defendants Abel, Nathan, and Baldoni removed the action to this court. Wayfarer filed an answer and counterclaims on March 20th, 2025. And the operative counterclaims on April 24th, 2025. In its counterclaims, Wayfarer alleges 2 claims for breach of contract. A claim for the breach of the implied covenant of good faith and fair dealing, and a claim for defamation per se. The Jones parties filed this motion to dismiss Wayfarer's counterclaims on May 8th, 2025. They also filed, sorry, my voice is going. They also filed a memorandum of law in support of the motion. Wayfarer filed a memorandum of law in opposition to the motion to dismiss on May 22nd, 2025. And on May 29th, 2025, the Jones parties filed a reply memorandum of law in further support of their motion to dismiss. So this has been sitting on the docket for 10 months. It's been waiting for this ruling for 10 months. I'm not reading anything into that. There's no trial deadlines or anything. It's not like the lively docket where, we're still waiting for the rulings on the motion for summary judgment and motion for judgment on the pleadings. And, they're about to start pre-trial motions like, it was supposed to be next Friday, but it's been delayed by a week. And it's like, these rulings would be really helpful to, let everyone know what claims are going to stay and what are going. But we're not in that situation here on this docket. There's no deadline set. So, but I am glad that Judge Lyman has now kind of addressed it, so we know where we're going with this. Okay, so we'll go past legal standard. So discussion. So we're going to look at exactly what the claims are, what's being dismissed and what's not being dismissed, and Judge Lyman's reasons for it. The Jones parties argue that Wayfarer's counterclaims for breach of contract, breach of the implied covenant of good faith and fair dealing, and defamation must each be dismissed for failure to state a claim for relief. The court discusses each in turn. Okay. Breach of contract. Wayfarer alleges 2 distinct theories of breach of contract. First, it alleges that the Jones parties breached the agreement by failing to abide by the confidentiality provision contained therein. Second, it argues that the Jones parties breached the agreement by failing to perform their services in a professional manner as required by the agreement. Neither party disputes that the contract is valid and enforceable. The court applies New York law to the breach of contract claims in accordance with the choice of law provision contained in the agreement. Okay. So, firstly, breach of the confidentiality provision. Wayfarer's first counterclaim alleges that the Jones parties breached the confidentiality provision of the agreement. Wayfarer alleges that the agreement requires Jones Works to use its reasonable and diligent efforts to preserve the confidentiality of Wayfarer's confidential, proprietary, and/or sensitive information, and that Jones Works breached that obligation by disclosing Wayfarer's confidential information to third parties, including Sloan, Lively, and Reynolds. The Jones parties argue that Wayfarer's claim for the breach of the confidentiality provision fails because 1. Wayfarer has not identified any confidential information that was disclosed, and in fact has pleaded that the information was Abel's private communications. And 2, The allegations are barred by the Federal Speak Out Act. And 3, Wayfarer has not pleaded damages. The elements of breach of contract under New York law are 1, the existence of an agreement, 2, adequate performance of the contract by the plaintiff, 3, breach of contract by the defendant, and 4, damages. The sufficient pleading for breach of contract must at minimum allege the terms of the contract, each element of the alleged breach, and the resultant damages in a plain and simple fashion. New York courts require plaintiffs to plead the provisions of the contract upon which the claim is based. In other words, a complaint in a breach of contract action must set forth the terms of the agreement upon which liability is predicated. To plead a claim for disclosure of confidential information, a plaintiff must allege facts showing that there was confidential information belonging to him that was disclosed, identify the information, and plead sufficient facts that a reasonable inference can be drawn that the defendant was the source of the information. Wayfarer's claim for breach of the confidentiality provision fails because Wayfarer does not allege any information that was protected by that provision that was improperly disclosed by the Jones parties. The definition of confidential information under the agreement is carefully drawn. The information must have been disclosed or provided by Wayfarer to Jones Works. There would therefore be no breach of the confidentiality provision if the information disclosed does not reveal information disclosed or provided by Wayfarer. Additionally, the confidential information as defined must be confidential, proprietary, and/or sensitive, and must concern Wayfarer, its customers, or other related parties. Okay. Agreement is expressed that such confidential information does not include information which is or later becomes publicly available through no wrongful act of Jones Works or information independently developed by Jones Works without reliance on information disclosed by Wayfarer. It notes too that Jones Works is not liable for any third party's disclosure of clients' confidential information, so long as such third party did not obtain the confidential information as a result of the company's breach or failure to uphold its obligations hereunder. In their briefing in opposition to the motion to dismiss, Wayfarer relies primarily on allegations with respect to messages taken from Abel's iPhone that were shared with the Lively parties and the media. Drawing all inferences from the facts pleaded in the counterclaims in favour of Wayfarer, it could be inferred that the contents of Abel's iPhone included information that revealed that Abel and others in Wayfarer's circle held Lively in deep disdain. It further might be inferred that the contents included information about the public relations campaign proposed by Abel to Wayfarer, but none of those allegations indicate that the information the Jones parties disclosed was confidential information as is defined in the agreement. Aside from the insufficient conclusory allegation that it was confidential information as defined in the agreement, plaintiff makes no allegation that any of the information on Abel's iPhone was in fact disclosed or provided by Wayfarer to Jones Works. To the contrary, as alleged, those messages were Abel's private communications with individuals in the Wayfarer circle and were not communications provided to Jones Works by Wayfarer within the terms of the agreement. This is not an unfair. His explanation here is actually quite fair and reasonable, I do think. I know that's not going to be a popular opinion. And we don't know the full extent of what was shared. You've seen the subpoena, it's quite broad, what it asks for. But Wayfarer do allege and do refer to the communications as Abel's private communications, and therefore that would make sense that if Abel was bringing this counterclaim for breach of contract, then it would possibly succeed. But Wayfarer sharing information with Abel, Wayfarer, unless there's more than Abel's text messages and the contents of her iPhone, unless there's more, and it was like information that Wayfarer provided to Jonesworks as a client of Jonesworks, which was disclosed as part of the subpoena, then unless that's the case, then I can see where Judge Lyman is actually going with this. Because if the legal standard is that Wayfarer need to be the ones to disclose or provide confidential information to Jonesworks, which then becomes the subject of what Jonesworks disclosed to Lively, then I can't see that it's actually been pleaded that that's what's happened, because in their own pleadings, Wayfarer do concede that the information that was shared was Abel's private communication from the iPhone. And it may be that they don't actually know the full extent of the disclosure to Lively or Van Zandt. Yeah, so based on the information we have available, I see, I can at least appreciate where Judge Lyman is going with this thought process. Again, I'm not saying that it's right or wrong, but it sounds like he's adhering to the law and the legal standard. So, I still think Stephanie Jones is a massive twat bag, though. So, I do. I'd love to see her get a comeuppance. I think she's probably one of the worst of all of these lot for her part. But yeah, Judge Lyman's got to uphold the law as it is. You can't stretch that, really. Okay. Yeah. Wayfarer highlights too its allegations that Jones falsely told Sloan that Wayfarer, along with Abel and Nathan, had orchestrated a malicious smear campaign to destroy Lively's reputation as evidence of disclosure of confidential information. Again, however, Wayfarer does not allege that this communication contained any information provided by Wayfarer to Jonesworks. An important distinction to make there is like, and I think this is what Judge Lyman is sort of saying is, look, you may have this belief, you may even have information that proves that that Stephanie Jones falsely told Leslie Sloan that Wayfarer, Abel, Nathan were orchestrating a malicious smear campaign, and this is evidence of the disclosure of confidential information. I completely get on board with that's likely what happened, actually. But what Judge Lyman is saying here is you didn't kind of allege that, like, what information. They needed to say exactly what information was being disclosed. So yeah. Instead, the allegation maintains that such communication did not reveal information disclosed or provided by Wayfarer because Jones knew full well that Wayfarer was scarcely engaging with the press at all. In other words, Wayfarer alleges that such smear campaign never took place and could not have been the subject of communications with Jonesworks. An allegation that Jones told Sloan false information about Wayfarer's actions cannot also be an allegation that Jones revealed confidential communications. So I can see where he's going there. He's like, well, basically you kind of mooted the assertion that, confidential information was shared about a smear campaign that did not happen. And the reason it's been mooted is because you're saying that Jones knew it didn't happen. Ergo, there wouldn't be information to share to try and falsely claim that Wayfarer embarked on a smear campaign against Lively. And what Lyman is basically saying there is, look, saying that Jones told Leslie Sloan falsely information about Wayfarer's actions cannot also be an allegation that Jones revealed confidential communication. So lying is not the same as sharing confidential information, which the breach of contract requires. Wayfarer has not alleged that any Jones or Jones work. I do not like the word in there. Wayfarer has not alleged that Jones or Jones Works disclosed any confidential information as contained in the agreement. Accordingly, the motion to dismiss count 1 of the counterclaims is granted. As this claim is dismissed, the court has no occasion to consider the Jones party's argument that Wayfarer failed to allege that it suffered any harm, or that the Speak Out Act bars enforcement of the confidentiality clause. And I was very critical of Stephanie Jones's attempt to hide behind the Speak Out Act. So I'm glad I'm a little bit disappointed that it didn't need to be talked about here, because I would have loved to have gone through that. But it's a moot point now, because the cause of action is now dismissed. So the second part of the breach of contract would be the breach of professional manner provision. In its second counterclaim, Wayfarer alleges that the Jones parties breached the obligation to provide services in a professional manner and in accordance with the goals mutually established by Wayfarer and Jones. Wayfarer argues that this provision was breached in several ways. 1. Jones was in Europe and largely incommunicado during the critical month of August when the film premiered. 2. Jones contacted a Daily Mail reporter about a story that they had published about Baldoni and Lively in violation of Wayfarer's directive and in blatant disregard of Wayfarer's strategy. And 3. After Wayfarer instructed Jones to cease all activities on behalf of Wayfarer and Baldoni, Jones insisted that she could do whatever she wants to clear her name, and emailed a number of key Sony executives working on the film, placing all blame on her team. The Jones parties argue that the complaint does not allege facts that would support the claim that they acted in an unprofessional manner or failed to follow mutually established goals. Now, I have no doubt that they were unprofessional. I have seen her Glassdoor reviews. However, as I've said this several times, in support of Wayfarer against Lively, the fact that she's acted unprofessionally into other staff members or other clients does not prove that she has done so with Wayfarer or Able, but I absolutely do think that she has. But we'll continue and see what Lyman says. Wayfarer has failed to state a claim that Jones Works breached the obligation in the agreement to act in a professional manner and in accordance with the parties' mutually established goals. The primary task of the court in assessing whether a complaint has stated a claim for a breach of contract is to interpret the contract and to assess whether the alleged facts, assumed to be true, violate the contract. Under New York law, courts interpret contract provisions in accordance with their plain and ordinary meaning. The court must examine the entire contract and consider the relation of the parties and the circumstances under which it was executed. Particular words should be considered, not as if isolated from the context, but in the light of the obligation as a whole and the intention of the parties as manifested thereby. A contract must be construed in a manner which gives effect to each and every part so as not to render any provision meaningless or without force or effect. At the motion to dismiss stage, a court must resolve contractual ambiguities in favour of the plaintiff. Jones Works did not have a freestanding obligation under the agreement to act in a professional manner in all respects. It had an obligation to act in a professional manner in connection with the required services, i.e., to provide the services in a professional manner. Services is a defined term under the agreement. The agreement defines the services as the strategic communication services as described on the attached Schedule A. The attached Schedule A describes 5 categories of services. They include, for example, managing media and press communications, and advising on any marketing and campaign strategies to ensure brand messaging is consistent, opportunities are maximized, and the strongest press angles aligned. If additional services were requested, i.e., services other than those designated on Exhibit A, Wayfarer was required to pay an additional negotiated fee. The services contemplated in the agreement do not include crisis management. Moreover, the agreement does not specify a particular employee of Jones Works who is to devote their time and attention to provide services for Wayfarer. Indeed, the only specific reference to Jones in the agreement relates to the covenant on the part of Wayfarer and not Jones Works, that if Jones Works develops creative material to pitch to production companies, Jones will be attached as no less than a co-executive producer. Thus, under the agreement, Jones Works itself, and not Jones specifically, was required to provide each of the services in a professional manner. As long as it provided the services themselves in a professional manner, it would have satisfied that covenant, even if, in the perception of Wayfarer, Jones Works or Jones herself fell short in some other respect. Okay. The term professional itself may be an indefinite and subjective term with multiple potential meanings. But in order for Wayfarer to assert a claim that Jones Works failed to satisfy its obligation to perform a service in a professional manner, it must allege that there was a service that Wayfarer failed to professionally perform. The counterclaims do not identify any respect in which Jones Works failed to perform the promised services in a professional manner. Indeed, it does not identify any of the services themselves. Wayfarer appears to rest its claim on the allegation that prior to July-August 2024, Jones had been disengaged from the Wayfarer account and was not privy to its communication strategy or internal decision-making, having long claimed to be too busy with higher-profile clients. But as noted, Wayfarer's contract was with Jones Works and not with Jones personally. Jones was not required by the agreement to devote any of her time and attention to Wayfarer. And as to Jones Works itself, the complaint suggests that Jones Works was performing the services in a professional manner. While Jones may not have been working on the Wayfarer account prior to August 2024, Abel was working on the Jones Works account, and Wayfarer affirmatively alleges that it had developed a close and trusting relationship with her. Again, this is not unfair, this is not unreasonable. Oh, I don't like it, but that's the way it is. So unless the contract specifies that Jones herself has to dedicate time to Wayfarer/Baldoni's account, then she is not obligated to. And what Lyman is saying is, well, the contract says that Jones Works will provide services in a professional manner, and Abel was representing Jones Works, and Wayfarer have confirmed that, they had a close, trusting relationship with Abel as the representative for Jones Works. I can't argue with that side of things. He's right. Moreover, while Wayfarer alleges that at the time of the public relations crisis, Jones was on a lengthy vacation in Europe, Wayfarer also alleges that as soon as Abel gave notice to Jones Works, Jones started participating in meetings, calls, and written correspondence to reassert her authority over the account and convey her engagement to Wayfarer. And on August 21st, 2024, when Abel's employment was terminated, Jones wrote that Jones Works was prepared to support Wayfarer's public relations needs. In any event, Wayfarer identifies no provision that would have required Jones personally to have devoted substantially all of her time or even any particular amount of time to work on the Wayfarer accounts. The counterclaims do allege that Wayfarer was unhappy with Jones's ideas and unhappy with her services before and after August 21st, 2024. Wayfarer alleges that Jones's efforts on its behalf were ham-fisted, unwelcome, and sporadic, and that Wayfarer and Baldoni now viewed Jones as a walking disaster who had demonstrated an astonishing degree of self-absorption, disloyalty, and insubordination during an existential crisis. The counterclaims detail some of the conduct to which Wayfarer was opposed. In mid-August 2024, Jones advised Wayfarer that it should fight for every story because Baldoni was not being represented in the stories that were being published, and that it should flood the zone with positive narratives about Baldoni that media outlets cannot ignore. She also advised that in response to the negative stories that were being published about Baldoni, Jones Works and PR should prepare alternate stories and mobilize a robust network of supporters and third-party advocates to make clear that the claims being made are untrue and unfounded. Wayfarer chose not to heed that advice. But Wayfarer does not allege what contractual provision Jones violated by providing that advice, even if it was not accepted. Jones Works was being retained in part to provide advice. Wayfarer need not have accepted that advice, but without more, its provision would not violate the agreement. Wayfarer also does not allege facts that would support the claim that Jones Works failed to act in accordance with the parties' mutually established goals. Wayfarer suggests that Jones violated an instruction of Wayfarer by contacting a Daily Mail reporter and by emailing a number of key Sony executives in an attempt to save face, after Wayfarer told her not to contact them to clear her name. But the contract required Jones Works to act in accordance with the parties' mutually established goals, not in accordance with Wayfarer's unilaterally set directives. I do have an issue with that. I don't like that, because that sounds like, if you're hiring PR and you tell them don't do something, but they go and do it anyway and it causes you problems, like it did here, it kind of sounds like the judge is saying, yeah, well, that's okay. She can do that. And I don't like that. I don't agree with that. Quite strongly, I don't agree with that. If I'm hiring someone for a service, and I don't want something done, then there should be that freedom of choice. At the end of the day, the client is paying for the service. And as Judge Lyman said, literally only a few sentences before that, Jones Works was being paid for advice. And Wayfarer have the choice to accept the advice. But I do think it should work the other way around as well, where, if Jones is saying, we're going to take this action, and Wayfarer saying, no, don't, I do think there should be an obligation on Jones Works to, not just Jones personally, but Jones Works, to not do that. Because now they're being sued for a smear campaign. And if the PR were doing that smear campaign on their behalf, even though Wayfarer have said don't do anything, well, they're the ones that are going to get sued. It's not a fair situation to put clients into. Moreover, the allegations are telling for what they admit. Wayfarer alleges that he instructed Jones not to talk to the press but the counterclaims do not allege that she did talk to the press. Well, they kind of did. She did try to contact. No, I don't know. They did allege that she contacted the Daily Mail. To the contrary, merely states that Jones left word with the reporter, not that they were ever in direct communication about the matter. I thought someone from Daily Mail or Sony specifically said that they named Stephanie Jones. Okay. The counterclaims includes also a text sent from Jones to a Wayfarer representative, noting that she attached my phone record so you could see that I did not call Daily Mail or receive/make calls to any media. There is no allegation that Wayfarer's instruction about talking to the press was ignored. Moreover, as Wayfarer admits, the agreement on its face does not give Wayfarer the right to have JonesWorks or Jones follow any instructions it might give. I struggle with that one. It requires only that JonesWorks act in accordance with the goals mutually established. Wayfarer does not allege how Jones's emails to the Sony directives violated her obligation to perform the services specified in the agreement in a professional manner, and does not identify any provision that gave it the right to demand that she not take action to clear her name when she believed that such action was necessary. Accordingly, the motion to dismiss count 2 of the counterclaims is granted. Again, I actually do believe that if Stephanie Jones had proof that she was being falsely accused of something, then I do think she has the right to defend herself, because her reputation is also on the line. And I would say that about anyone. I would say, well, Wayfarer, if they were falsely accused, like they are right now, being falsely accused of something, they have the right to defend themselves, defend their reputation, and come with their proof. So I feel like it would be quite unfair then to say, well, Stephanie Jones is being, she was accused of contacting Daily Mail and disregarding instructions. Now, we're all picking sides here. And, it's obviously after we've seen the evidence and the proof. But there are certain things that we do not know for sure. Some of the evidence does actually point to Jen Abel as being, the leak or the person who contacted the press. But again, I don't know. I don't know who did. But Stephanie Jones was quite adamant she wanted to clear her name. She wasn't asking Wayfarer to clear her name. She wanted to do it herself. And I don't think that for anyone at all, that is an unreasonable request. Okay. Breach of the implied covenant of good faith and fair dealing. Wayfarer's third claim alleges a breach of the covenant of good faith and fair dealing. Wayfarer alleges that JonesWorks and Jones engaged in conduct that prevented Wayfarer from receiving the benefits contemplated under the agreement, including by maliciously feeding its confidential information to hostile third parties for the specific purpose of harming Wayfarer and Baldoni, acting against Wayfarer's interests and otherwise depriving Wayfarer of the benefit of its bargain. So to be clear, the first two causes of action, the breach of contract claims, they have been dismissed. Right, so this is the breach of the covenant of good faith and fair dealing. Under New York law, a covenant of good faith and fair dealing is implied in all contracts. This covenant embraces a pledge that neither party shall do anything which will have the effect of destroying or injuring the right of the other party to receive the fruits of the contract. The implied obligation is in aid and furtherance of the other terms of the agreement of the parties. Accordingly, no obligation can be implied, which would be inconsistent with other terms of the agreement of the parties. Additionally, if the defendant had a genuine and colorable business justification for its decision, then its actions will not have been arbitrary and thus will not have violated the implied covenant. Wayfarer alleges that in the wake of the Jones Works terminate. Oh, sorry, I just dropped something. Wayfarer alleges that in the wake of the Jones Works termination of Able and in the wake of Wayfarer's announcement that it would terminate its agreement with Jones Works set out to injure its departing client. Upon information and belief, Jones Works. Oh. Bear with, sorry. Ugh. There we go. Upon information and belief, Jones Works told Lively's publicity team that Abel and Nathan had orchestrated a campaign to destroy Lively's reputation. Prior to the termination of its contract with Wayfarer, Jones Works also allegedly turned over private messages that would harm Wayfarer's relationship with Lively. Now, see, this is where it is right then for, instead of saying, well, they breached contract by sharing confidential information, and proof of that is that they told Lively that there was a smear campaign, which there wasn't. This is the right place to bring that kind of allegation. And that's what they're doing here. So I think Wayfarer half expected one of them to fail and the other to succeed, which is what's happened here. Among the services Jones Works agreed to perform was to manage media and press communications and to advise on any marketing ad campaign strategies to ensure opportunities are maximized and the strongest press angles aligned. Jones Works also agreed to position and utilize Wayfarer Studios' key executives as thought leaders and change agents in the film and television industry. It could be inferred that implicit within their obligation was the covenant not to destroy Wayfarer's existing opportunities. Jones Works' primary argument in support of its motion to dismiss is that when a complaint alleges both a breach of contract and of the implied covenant of good faith and fair dealing based on the same facts, the latter claim should be dismissed as redundant, and that's what Jones Works has argued, basically. And the judge says the argument misses the mark. So what's actually happened is the opposite. Similar allegations in both the breach of contract and the covenant of good faith and fair dealing. Jones Works wants the covenant of good faith and fair dealing dismissed. She's argued for that to be dismissed because they're already claiming the same thing pretty much in the breach of contract claims. And the judge is saying no, and he's actually done the opposite. The redundancy restriction on implied covenant claims applies only where the facts alleged to establish breach of the implied covenant actually go toward establishing a violation of one of the expressed provisions in the contract. A claim for a breach of the implied covenant will be dismissed as redundant where the conduct allegedly violating the implied covenant is also the predicate for a breach of covenant of an express provision of the underlying contract. A plaintiff can plead a claim for breach of the covenant of good faith and fair dealing where there is a dispute over the existence, scope, or enforceability of the putative contract. Courts dismiss a breach of covenant of good faith and fair dealing claim where it is merely a substitute for a non-viable breach of contract claim. But that is just another way of saying that the covenant of good faith and fair dealing cannot be construed so broadly as to effectively nullify other expressed terms of the contract or to create independent contractual rights. If the parties expressly bargained for one provision and not for another, then it would contravene the contract to nevertheless recognize as implied an unstated claim. That is in contrast to a successful implied covenant claim, which exists only where a party to a contract takes action that would destroy or injure the right of the counterparty to receive the fruits of the contract. Here in Part 1, the court discussed at length that Wayfarer is incorrect that the conduct alleged in the counterclaims constituted either the impermissible disclosure of confidential information or failure to perform the services in a professional manner. Thus, there is no contractual provision that would cover the conduct alleged in the count for breach of the implied covenant of good faith and fair dealing that Jones Works and Jones engaged in the conduct that prevented Wayfarer from receiving the benefits contemplated under the agreement, including by maliciously feeding confidential information to hostile third parties for the specific purpose of harming Wayfarer and Baldoni, acting against Wayfarer's interests and otherwise depriving Wayfarer of the benefit of its bargain. Okay. The fact that Wayfarer misguidedly attempted to use certain facts to bring a claim for breach of contract does not then preclude an implied covenant count where those express provisions do not cover the conduct at issue. The ultimate question that then remains is whether the Jones party's conduct violated the covenant. Where necessary so as not to deprive the contracting party of the fruits of the contract, the court will not hesitate to infer an obligation to act in good faith. At the motion to dismiss stage, it is plausible to infer that Wayfarer hired Jones Works to develop relationships with other media figures like Lively, and that the sharing of negative information about Wayfarer with Lively would undermine the object of the agreement. The parties need not have expressly agreed that Jones Works would not convey negative information to third parties about its client for a reasonable person in the position of the promisee to be justified in understanding that such a provision was included in the contract. There is no question that the actions Jones Works is accused of having taken would have been viewed as defeating the object of the services to be provided if they were taken at the incipiency of the relationship. Taken as true, they are not less destructive of the object of the relationship because they were taken in its twilight. Accordingly, the motion to dismiss count 3 of the counterclaims is denied. So, Jones Works has been denied. That claim will stay. Defamation per se. Wayfarer's fourth claim is for defamation per se. Wayfarer alleges on information and belief that Jones and Jones Works made one or more statements to persons other than Wayfarer, including without limitation Leslie Sloan, Blake Lively, and Ryan Reynolds, to the effect that Wayfarer had retaliated against Lively and others for reporting alleged sexual misconduct, including orchestrating a smear campaign by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. The Jones parties argue that Wayfarer has failed to state a claim for defamation because 1. The complaint does not allege falsity. 2. The statement regarding a smear campaign is quintessential protected opinion. And 3. Wayfarer has failed to allege actual malice. The court first determines the law to apply to Wayfarer's claim for defamation. The Jones parties argue that the court should apply New York law. Wayfarer argues that the court should apply California law. A federal court sitting in diversity borrows the forum state's choice of law rule. Under New York's choice of law rules, the first step in any case presenting a potential choice of law issue is to determine whether there is an actual conflict between the laws of the jurisdictions involved. The elements of a claim of defamation are similar under New York and California law. Under New York law, a defamation plaintiff must establish 5 elements. 1. A written defamatory statement of and concerning the plaintiff. 2. Publication to a third party. 3. Fault. 4. Falsity of the defamatory statement. And 5. Special damages per se actionability. Under California law, the tort of defamation involves A. A publication that is B. False, C. Defamatory, and D, unprivileged, and that has E, a natural tendency to injure, or that causes special damage. Publication need not be made to the public at large. Communication to a single individual is sufficient. Where the two bodies of law differ is on their approach to the distinction between facts and opinions. The New York Constitution provides independent protection for statements of opinion. The factors to be considered in determining whether a statement is one of fact or opinion are 1. Whether the specific language in issue has a precise meaning which is readily understood. 2. Whether the statements are capable of being proven true or false. And 3. Whether either the full context of the communication in which the statement appears or the broader social context and surrounding circumstances are such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. New York courts adopt a holistic approach to determining whether a statement is fact or opinion, including consideration of the content of the communication as a whole, its tone, and apparent purpose. California defamation law incorporates and follows the more limited speech protections required by the First Amendment to the United States Constitution. Given that there is a conflict in defamation law that could have an impact on the outcome of the motion, the court must determine which law to apply. Although there is a choice of law provision in the agreement, it does not control the court's choice of law determination. The choice of law provision states that the agreement is governed by, construed under, and enforced in accordance with the laws of the state of New York, applicable to agreements made and to be fully performed herein. The court applies the law of the forum, here, New York, to determine the validity and scope of a contractual provision. Under New York law, the court applies the law selected in contractual choice of law clauses only to causes of action surrounding in contract unless the express language of the choice of law provision is sufficiently broad as to encompass the entire relationship between the contracting parties. The agreement's choice of law provision is narrow and not broad. It applies only to the construction and enforcement of the agreement. It does not address tort claims that may arise between the parties as a result of or during the relationship formed by the agreement. In the absence of an applicable choice of law provision, New York has adopted an interest analysis, which requires that the law of the jurisdiction having the greatest interest in the litigation be applied. To make that determination, New York courts ask: 1. What are the significant contracts and in which jurisdiction are they located? And 2. Whether the purpose of the law is to regulate conduct or allocate loss. A conduct regulating law is one that people use as a guide to govern their primary conduct. In Kinsey, the Second Circuit drew a distinction between defamation cases involving targeted publication and multi-state defamation cases. Ordinarily, under New York choice of law rules in defamation cases, the state of the plaintiff's domicile will usually have the most significant relationship to the case, and its law will therefore govern. Wayfarer does not allege a statement published nationally, but rather a single set of utterances made privately by Jones to Sloan about Wayfarer and Baldoni. Wayfarer is domiciled in California, therefore California law applies. Wayfarer alleges upon information and belief that Jones falsely told Lively's publicist that Abel and Nathan had orchestrated a malicious smear campaign to destroy Lively's reputation as retaliation for complaints Lively had purportedly made about sexual harassment on set. It alleges too that Jones continued discussions with the Lively parties over the subsequent months, reiterating the false allegation that Wayfarer had orchestrated a retaliatory smear campaign. As explained above, under California law, the tort of defamation involves A. A publication that is B. false, C. defamatory, and D. unprivileged, and that E. has a natural tendency to injure or that causes special damage. Something is defamatory in California if it exposes any person to hatred, contempt, ridicule, or obloquy, or if it causes him to be shunned or avoided, or if it has a tendency to injure him in his occupation. Furthermore, a libel which is defamatory of the plaintiff without the necessity of explanatory matter, such as an inducement, innuendo, or other extrinsic fact, is said to be libel on its face. When a defamatory statement is libelous on its face, the plaintiff is not required to prove that he has suffered special damages as a proximate result thereof. It is the province of the court to determine whether a statement is actionable as a statement of fact susceptible of a defamatory meaning versus a non-actionable statement of opinion privileged under the First Amendment. To determine whether a statement is actionable fact or non-actionable opinion, courts apply a totality of the circumstances test, pursuant to which they consider both the language of the statement itself and the context in which it is made. Courts look to the nature and full content of the communication and to the knowledge and understanding of the audience to whom the publication was directed. The publication is to be measured not so much by its effect when subjected to the critical analysis of a mind trained in law, but by the natural and probable effect upon the mind of the average reader. Distinguishing fact from opinion can be difficult, and what constitutes a statement of fact in one context may be treated as a statement of opinion in another. For example, the statement that the plaintiff has engaged in blackmail may convey a different meaning when it is uttered by the disappointed counterpart to a tough business negotiation than when it is pronounced by a prosecutor. Or the accusation that a person is a traitor may mean one thing in the context of a heated debate in a union hall and another thing entirely in the context of a national security briefing. Assertions that a person is guilty of blackmail, fraud, bribery, and corruption could, in certain contexts, be understood as mere non-actionable rhetorical hyperbole or vigorous epithets. In other contexts, such assertions could also be understood to be a statement of fact or to imply the existence of undisclosed underlying facts. There is no safe harbor. Context matters. So too with the use of the word smear or smear campaign. In common vernacular, it may be a hyperbolic way of responding that an accusation is untrue. The victim of a false public campaign may respond that she has been publicly smeared. Well, like this. I wonder if this is a bit of a hint of how Judge Lyman is looking at Lively's case now. So, the victim of a false public campaign may respond that she has been publicly smeared or been the victim of a smear campaign without necessarily opening herself to a suit for slander. Her statement could only be understood as a loose response to what she perceives to have been said against her. In context, the statement would not be understood as one of fact or to convey the existence of undisclosed facts. It would be a strong way of vigorously denying the accusation. Political opponents can accuse one another of engaging in smear campaigns based on their public statements without a trial on whether their respective statements were a smear or simply untrue. The term, however, can also be understood as a plan to discredit someone or something or to destroy a reputation by means of smears that is, by slanderous or defamatory remark, an attempt to defame by slander. So understood, it may be reasonably susceptible of an interpretation which implies a provably false assertion of actual fact. The statement may connote that the subject has intentionally executed an undisclosed plan to knowingly spread false and defamatory remarks about another for some impermissible purpose. The complaint pleads facts that make it plausible that a jury could construe Jones's comments in the latter fashion. Wayfarer alleges that Jones made comments to Sloan that Wayfarer, Abel, and Nathan had orchestrated a malicious smear campaign to destroy Lively's reputation as retaliation for Lively's complaints about purported sexual harassment on set. The statement could be understood to convey that Jones was in possession of some undisclosed underlying facts. Jones was Wayfarer's publicist. She would have been privy to Wayfarer's plans and to its actions. It was her job to understand and implement Wayfarer's public relations strategy. The statement thus carries a clear or natural indication that Jones had actual knowledge of the activities of her client and former employee. Jones's statement would carry a ring of authenticity and reasonably might be understood as being based in fact. She would know the source of the allegedly defamatory statements about Lively, and if the source was Wayfarer, even if Lively and Lively's publicist did not know the source. A jury could determine whether, in fact, Wayfarer had executed a plan to destroy Lively's reputation and career by means of false and defamatory statements. Moreover, as alleged, Jones did not simply accuse Wayfarer of engaging in a campaign to destroy Lively's reputation through false statements. Jones allegedly told Sloan that Wayfarer undertook to discredit and destroy Lively's reputation because she had complained about sexual discrimination on the set of the film. That too is a statement that can be subject to the test of factual truth. Assuming that Wayfarer engaged in a secret campaign to spread false information about Lively to destroy her reputation, a jury could determine affirmatively whether it did so because she had complained about sexual discrimination or for some other reason. That Wayfarer would undertake any kind of negative campaign against Lively for complaining about sexual harassment on set could be understood to be defamatory, regardless of the extremity of what that smear campaign did actually entail. The Jones parties argue that even if the statement is actionable as defamation, the count must be dismissed because it is not false. To be defamatory, a plaintiff is ultimately required to prove that the alleged fact is false. Wayfarer alleges that the statements made by Jones and Jones Works about Wayfarer were false, as not only was Jones well aware that Lively had not actually been harassed on set, she also knew that there had not been a smear campaign. That is sufficient to survive a motion to dismiss. Okay, this is really good stuff. I mean, I like this. I like his thought process in this. Additionally, the Jones party's contention that the fact that the smear campaign is demonstrably true by reference to other allegations in the complaint is unavailing. The assertions they cite do not prove that Wayfarer engaged in a smear campaign. The Jones parties point only to allegations that Nathan was hired as a PR expert and that persons in the Wayfarer circle held Lively in deep disdain. It is clear that neither of those statements admit the execution of a smear campaign in retaliation for Lively's actions. Finally, the Jones parties argue that because Wayfarer is a public figure, it is required to plead actual malice to state a claim for defamation. Actual malice requires that the statement be made with knowledge that it was false or with reckless disregard of whether it was false or not. The reckless disregard standard requires a high degree of awareness of probable falsity. There must be sufficient evidence to permit the conclusion that the defendant in fact entertained serious doubts as to the truth of his publication. For defamation purposes, a person can be a general public figure who has achieved such pervasive fame or notoriety that they become public figures for all purposes and in all contexts, or a limited purpose public figure who has voluntarily injected himself or been drawn into a particular public controversy and thereby becomes a public figure for a limited range of issues. Regardless of whether one is an all-purpose or limited-purpose public figure, pleading actual malice is required. The determination is made based on the totality of the circumstances, and there is no bright-line level of notoriety that one must achieve to be deemed an all-purpose public figure. Ultimately, actual malice can be proved by circumstantial evidence, and considerations such as anger and hostility toward the plaintiff, reliance on sources known to be unreliable or known to be biased against the plaintiff, and failure to investigate may be, in an appropriate case, indicate such malice. As to Wayfarer, the standards for determining whether a party is a public figure apply equally to individuals and business entities. Wayfarer is at least a limited-purpose public figure. An entity may become a limited-purpose public figure where it voluntarily injects itself or is drawn into a particular public controversy and thereby becomes a public figure for a limited range of issues. Wayfarer was founded by Justin Baldoni, a well-known actor, and acquired the rights to the film, financed and distributed it, and was responsible for casting. This suit arises out of the fallout from the massive PR crisis in which Wayfarer was involved following production and distribution of the film. It is precisely because Wayfarer was a public-facing entity that those services were required. The fallout from the dispute between Jones and Wayfarer was similarly public. Because it is at least a limited-purpose public figure, Wayfarer is required to allege actual malice. It has done so here. Wayfarer alleges that Jones knew the statement she made to Sloan was false, as not only was she well aware that Lively had not actually been sexually harassed on set, she also knew that there had not been a smear campaign. This is clear because Jones was copied on many of Wayfarer's email and text threads during the relevant period, and knew full well that Wayfarer was scarcely engaging with the press at all in August 2024, much less carrying out offensive tactics in retaliation for something that never happened. Those allegations accepted as true clarify that Jones made the statements knowing that they were false, or with at least reckless disregard of whether they were false. It is plausible that as Wayfarer's publicist, Jones was in a position to know the veracity of her statements at that time. Accordingly, plaintiff has stated a claim for defamation, and the Jones party's motion to dismiss count 4, defamation per se, is denied. Conclusion: the motion to dismiss is granted in part and denied in part. Counts 1 and 2, so that'd be the breach of contract, and the breach of the requirement to act professionally, provide professional services. All of the counterclaims are dismissed with prejudice. So, they're dismissed with prejudice, right? The motions to dismiss counts 3 and 4, that is the covenant for oh, I've lost it now. Covenant for fair dealing. Yeah. And defamation. They are denied, so they will continue forward, those two causes of action. It made some very interesting points, actually, for both the causes of action that he has dismissed and for the ones that he's not going to dismiss. Overall, I'm not overly disappointed. There was that one part that I was a bit frustrated with, the kind of suggestion that, the contract didn't say that Jones has to do what she's asked, kind of thing. Well, I mean, technically, he's right, but I do also feel that a paying client, if they expressly state, "Please don't do this," especially as Jones, by her own admission, had not been involved, in the day-to-day of dealing with Lively, and was kind of coming back into things, um, after not really being involved. I do feel like if you pay for a service and you say, "Please don't do this because it's going to cause me more problems if you do than if you don't," I feel like people who pay for those services should have that right to do it. um, don't contact someone is not a big ask. Um, but I will defend not just Jones. I will defend anyone's right though if they're falsely accused of something, and they want, their reputation is kind of being tarnished. I'm not saying Jones had a good reputation to start with. She did not. I've been through that in very, very great detail. But, in that situation, she felt that she was being accused of something and she wanted to, at least attempt to restore the reputation. I mean, if she wasn't actually the person who leaked that story that caused the problem, then I do think that she has that right to do that. That's the one area I will push back, and I say that because what's Jen Abel doing right now? What's Melissa Nathan doing right now? What is Wayfarer and Justin Baldoni doing right now when they're all falsely facing false allegations which are harming their business and their reputation and their livelihood? They're all defending themselves. They're doing it in a court. So I don't think it's unfair for Stephanie Jones to say, "Hey, I just want to contact the people who are under this misapprehension that I've done something I didn't do." Okay. So, yeah, I'm kind of happy with that. We got the big claims that it's going to stay, and yes, I mean some claims are going, but at least it's not a complete dismissal. All right, guys. I'd love to know your thoughts though. It's a bit of a like I don't love say agreeing with the enemy, um, but I know I've always said that where I think that Judge Lyman is actually making a reasonable ruling, I will say that, and he did adhere to the law, and I couldn't argue with it. Yeah, but it's just it's frustrating though. All right, guys. Thanks for listening.